The DVD explains everything using the market capitalization of cryptocurrency. To ensure that I can keep broadcasting XRP and cryptocurrency news, I would really appreciate it if you could like and subscribe to my channel. Look at it this way. The United States Court of Appeals has made public the critical dates that Bradley Sostak has revealed regarding the explosive litigation that he filed against Ripple. Concerns about the MidSec closure surfaced after looking at the XRP lawsuit's court dates. Working around the clock, the U.S. Securities and Exchange Commission (SEC) is preparing to submit its main brief, all the while Chairman Gary Gensler is out of his office. Nevertheless, delays are possible due to the fact that government shutdowns may happen on occasion. So that's the way it is. Apollos must comply with critical dates established by the U.S. Supreme Court's appeals process. By no later than December 23rd, the plaintiff Bradley Sostak is required by U.S. law to have submitted a mediation question. Subsequently, the court needs the transcript of the appeals by December 31st and the complete transcript by January 30th. Sostak will lay out his claims against Ripple and CEO Brad Garlinghouse in his opening brief, which he will submit on March 6, 2025. Expect a response from Ripple Labs, XRPI, and Garlinghouse, even though the deadline is April 7, 2025. The appeal can be rejected if any of the involved parties fail to meet these due dates. Following a string of favorable court rulings and decisions, Ripple has issued its newest announcement. Regardless of the circumstances, Bradley Sostak will proceed with his allegations. Judge Phyllis Hamilton has recently given her approval to remove the case's stay and reconsider the verdict. Delaying the decision was unnecessary. Both camps maintain that their new proposals were an attempt to reach a consensus. This is so even though the class claims were resolved earlier. Get ready for the steamy closure. The CC is addressing its own problems concurrently with its role as a defendant in the lawsuit against Ripple. As concerns over the federal budget grow, the likelihood of a government shutdown in the United States increases daily. Some industry insiders have speculated that the Securities and Exchange Commission would put off responding to the appeal because of this problem, therefore delaying the completion of the current legal battle. There may be less immediate pressure on Ripple if this postponement is successful. Delays in a settlement could highlight XRP's administrative role. However, a new date has been set for the trial against XRP by the United States Court of Appeals, as stated in the statement. The district court received an appeal stating that Ripple Labs, XRPU, and CEO Brad Garlinghouse must reply to the appellant's main brief by April 7th of the following year, and the opening brief is due on March 6th of the following year. This is a significant development. The United States Securities and Exchange Commission is preparing to submit its main brief prior to Gary Gensler's resignation as chair, after it has been confirmed that it has received the notice of appeal. An allocated docket number was given to the Ripple case by the United States Court of Appeals for the Ninth Circuit. According to the Court of Appeals request, future motions requesting relief from this court must be handled differently. The plaintiff has 14 days from the date of notification to file a disclosure statement that is similar to an appeal with the United States Securities and Exchange Commission. The requisite paperwork was missing, hence we should reject the XRP case's appeal to the appeals court. It is required by the established order that the plaintiff Brad Sostak submit the mediation questionnaire no later than December 23rd. We expect to receive the order for the appeal transcript on January 30th and the actual transcript on December 31st. Beginning on March 6th, the plaintiff will present an opening brief in their appeals against Ripple and CEO Brad Garlinghouse. By April 7th, Ripple Labs, XRPE, and Garlinghouse must file their reply papers to the appeal. Once hearings have been reported, the parties are required under Rule 103 of the Ninth Circuit Rules of Procedure to identify and, if needed, cross-designate the transcripts. Without reported hearings, the transcript deadlines do not apply, according to the court's ruling. Leading plaintiff Bradley Sostak has contested rulings that favored artificial intelligence, XRP, Ripple Labs, and CEO Brad Garlinghouse, as previously revealed by C.O.G. Ripple was declared victorious by the district court. The motion to alter the judgment and stay the order was granted by Judge Phyllis Hamilton in the XRP case. Since the class claims had already been resolved, neither party saw the need to ask the court to delay judgment on their proposed orders. The central topic of debate is the ongoing Ripple v. SC litigation before the Second Circuit Appeals Court. Executives from Ripple will be overjoyed if the case is withdrawn or abandoned in the Bitcoin community. Some, however, are concerned that problems may arise as a result of Gary Gensler's departure on January 20th, which was 5 days beyond the major short deadline. Ripple and the SEC have been making progress in their legal fight as the hearings on January 15th approach. In a recent episode of the podcast hosted by Docket Media LLC, crypto skeptic and former SEC enforcement official John Reed Stark discussed the landmark Ripple verdicts. The Ripple decision, he argues, should not be applied to any case without similar unique characteristics, since it does not provide universal legal certainty. According to his research on the Ripple decision, many people erred in their interpretation of the verdict because they didn't read the paper carefully. Judge Torres was totally mistaken on several points, in his opinion and the opinion of other judges who have looked over the case multiple times. I must respectfully disagree with her on several points, as did Judge Rakoff and every other court that has addressed the Ripple case, even though I hold the Court of Tories in the highest regard. The general people have an utter misunderstanding of the Ripple decision. Stark noted that there were two sides to the Ripple ruling. At first, he agreed with the argument that XRP tokens should have been registered as securities when they were first offered to the wealthy. But Stark was not on board with that. If you want to know what the potential results of this market-altering legal dispute between Ripple and SEC are, you may read the XRP price prediction and keep one step ahead of the competition. Trades involving XRP took place on the secondary market. The decision made by Ripple was clouded. He thinks it's unfair to say that regular investors weren't safeguarded since Ripple didn't interact with them directly. He argued that this was an unjust perspective. As Stark pointed out, this is analogous to buying a company's shares, which entitles the buyer to protection from the firm's legal obligations, even in the absence of a contract. According to Stark, the Ripple verdict caused too much uncertainty, especially when cryptocurrency-supporting firms began claiming that tokens were cryptos instead of securities. In order to halt the ongoing procedures, the Securities and Exchange Commission transferred the UL interlocutory appeal.